Good morning, South Africa. Welcome to the EasyPOPI DIY Toolkit demo or seminar. It's the 14th of June, and this is Jacques here, and you're joined by my colleague. Joining me is my colleague Johan. What we aim to do today is go through the toolkit document by document and assist you with your implementation and try and address some of the frequently asked questions that we get. And hopefully this will assist you just to get some calmness before the deadline and implement a robust POPI manual. Johan, let's go to the set of documents. Johan and I will be chatting. All right, so starting with the instructions document number 1, or actually the first set of folders there is the office posters.
Yeah.
So we've decided to put some office awareness posters. You can implement the best POPI solution in the world and still be at high risk if you didn't onboard your employees. Your employees are your biggest liability. You can be compliant today at 2 o'clock in this afternoon. One of your employees sends the whole database to their cousin to sell them some other product, and then you breach. So we found it helpful to add some posters which you can print and just put up in your office or next to people's desktops just to help with some awareness. Yeah, Johan, you can move on to document number 1, which is the instructions. While Johan is going there, basically what you're creating is a set of documents and spreadsheets that all live on a folder, which essentially becomes your policies, procedures, and your POPI manual. Launching the project, as I said, it's a good thing to launch it officially and send some emailers and some newsletters or create a visual office. And then how to use the toolkit is very simple. You go through the documents in order of numbering. So we're in document number 1 now, and then we'll move on to document 2. And every document is broken down into steps 1 to 36, just to give you some sanity as you move through your project. When you come to the end of your project, there's a self-assessment tool or a gap analysis tool that you can use to score yourself. 100% is compliant, 99% is fail. And our philosophy is when you get to the end of it and you've got 2 or 3 or 5 areas that you haven't scored well in, at least you've taken all the pain out of the financial implication of getting a consultant to help you out. So if there's an area where you feel you haven't done well, you can ask us to do a consultation for you just to get you over the line. Then if you do get stuck, you are welcome to email us at info@easypopi.co.za just to give you some pointers. But obviously also right now we're doing the seminar to help you, so you'll be in a very good position at the end of it once you've watched it. Every document has a link at the bottom that takes you to a page on our website just to give you some pointers and some tips as to how to approach the document. We can move on to document number 2, and I'll hand over to Johan, and I will ask questions here and there where it's needed.
Document 2 is basically dealing with all your key definitions within the Act. It gives you background as to what is meant with all the various words. Normal legal terms can be simple to lawyers, but for most of us, it is jargon that doesn't make much sense. And so reading through this will help you to understand a little bit better what is meant by the different terms as and when you encounter them in the documents and in the questionnaires that we will deal with later on in the document as well. It is quite a comprehensive overview, but I think it's worthwhile spend the time and read through this.
Johan, as I'm reading this, is it right that I take it that this is not the full act, but it is a very robust and complete set of definitions that gives the person who hasn't dealt with the POPI Act at all just a very good idea as to what the Act is trying to manage and what it's trying to achieve?
Absolutely, it's not the entire act. It's very, very short in terms of what the definitions are, and it helps you to understand, like I say, when encountering questions, then at least you have an understanding of what it's about, but it will give you a thorough understanding and background.
Okay, I think we can go to document 3.
Document 3 deals with with the appointment of your officers within the company. The officers within your company are going to be your information officer, and where appropriate, a deputy information officer. Now, the Act defines, and in this case it's the PIA Act, Public Access to Information Act, defines who the information officer is. Information officer of the business is by default the head of the business, whether it be a company, whether it be a partnership, whether it be a one-man business. The head of the business is the information officer. The information officer may appoint someone as a deputy. The head of the business may also appoint another person as an information officer. But it's important to note that that role as information officer needs to be a senior position within the business.
So the deputy, Johan, we often get asked whether you have to have a deputy. If you're a smaller business and there's like 1 or 2 people or 3 people doing this, and somebody's been assigned the role of getting all the information together, do you have to have a deputy, or can you go without it?
No, a deputy is an optional role, and even in large companies where there are more than 150 employees, they seldom appoint a deputy information officer, as it is usually to alleviate the pressure on the information officer to deal either with the requirements of PIA or POPI. So it usually isn't really required in a smaller business.
So this is an internal document that you file with your other files, but then over and above this, you still have to go and register on the Information Regulators portal. Is that correct?
Jock, that's a good point. Many people think that if they only complete this document, they are fine. You have to, before the 30th or on the 30th of June this year, do the registration online with the information regulator. So yes, you're right. You have to do that. This is your internal proof of the process and the operation that you're doing inside your company, but it needs to also be followed through by doing the assignment on the portal of the information regulator.
Johan, before we move on, I just want to also mention that registering on the information portal is quite busy. It's busy at the moment, and the system is falling over. So you just have to try to register there. And also, once you've registered and it gives you a certificate, there's a lot of crooks in the market right now that are saying that that is your certificate of compliance, and they're selling a service saying we'll register for you and here's your certificate, and people think that they're now compliant. Compliancy is not a button you can push or a document you can file or anything like that. As we are going through the documents, obviously you'll see now that it's a process you have to put in place. Anyway, I just thought I'll mention that so we can move on to the next document.
Important to note that training within the organization is key. one needs to ensure as the information officer, and you'll be able to see the roles and the responsibilities of the information officer as well, makes it very clear that the information officer needs to ensure that the whole organization understands and is up to speed with the law. And this section here just helps you understand where you are in terms of training and communication with your stakeholders, so internal as well as external, be they your employees and on the outside, your suppliers, vendors, and customers, service providers, and the like. So it's important that everybody is up to speed and understands the background as to the requirements of the POPI legislation.
So in step 2, Johan, if I understand it correctly, the company identified all the third parties who may have a stakeholder interest in the personal information held by the company. Are these, like we've listed, the shareholders, employees, subsidiaries? These are anybody and everybody that has an interest in the business. How would you, in a nutshell, explain that category that we are looking for in step 2?
Anyone who is a stakeholder, exactly right. So this, and once again, this is not an exhaustive list. So it's anyone who's a stakeholder, and therefore it says as a stakeholder. Stakeholder is anyone who has an interest within your business that you might have personal information of. And it's important then to remember that the principle here is to protect personal information. If it's a stakeholder but you will not have any of their personal information, it's not really an issue. Put them down in any case, because it might be that you've forgotten at this point in time, but then tomorrow realize, oh dear, but I do have an email address over there, and that defines a record. And if you have a record of any personal information, whether it be of a company or a personal private individual, it still is personal information. So list as many as you can. You can rather remove them later on if you want, but try and be as exhaustive as you can before the time.
Johan, okay, so let's show the audience. It says they record this in the master file in a sheet called stakeholders. Can you go to the Excel spreadsheet just to give one example under stakeholders? Maybe make it a little bit bigger, just zoom in so we can see it nicely. All right, so I identified a stakeholder and employee. Is that a stakeholder?
Employee can be a stakeholder, you're 100% right. So you can say the employee.
So you're listing stakeholder groups now. So you'll say employees or just employee. You're not going to, if you've got 100 employees, you're not going to do 100 entries. Am I right?
That's right. No, there's no need for 50 or 100, depending on how many people you are. So the type of stakeholder. So in this instance, it's not listed as one of the drop down, but you can add it in there. And you can
just go up a little bit. I see where it scrolled all the way down. Your scroll bar, go to the top.
Right. Okay, there you go. Agents.
Employees in the company. Okay. Okay.
There you go. All right. Super.
All right. So responsible person inside or outside organization that will send communication. So we need to communicate to our employees, and I need to now say who is going to be doing that communication.
Absolutely. So a responsible person inside or outside that will send communication. Now, in terms of sending communication, what does sending communication means? It will be in your internal side, it will probably be your personnel officer, or it might be the Indian side. So, but let us use in this case, personnel officer.
So somebody in HR typically.
Could be, yes, indeed.
Yes, could be.
And then communication method. Once again, consent forms, contracts. Usually, in terms of your employees, you would have a contract with them already. And,
okay, and then just another question. So what is this communication I'm sending? Is it communication that we are complying to the POPI Act, or what are we sending?
no, this is not about being compliant. This is about how and what information you would and could send by means of which methods. So internally, it could be by a variety of means, but what is the one that you're dealing with at this point? And remember, training is not the same as the stakeholder in this instance. What you've identified is your stakeholder, in this case, employee of the company. The person responsible inside or outside that will send communication will usually be your personnel officer. And what would the normal way be for sending that communication within the business? And potentially, you're not going to send random bulk emails within the company about contracts. So you will potentially do that item by item, line by line, with every person involved.
Okay, so typically in our pack here, we've got an annexure for the employee, so it'll be a contract, right? The
Correct.
one that we'll go through that document just now.
Yeah, it'll form part
okay.
of the contract.
All right, let's move on.
Okay. So let's continue. So this we've previously gone through governing bodies, refer to the groups, conduct your training online. You can do physical. There are textbooks for training. There are various means. Important to remember to keep your records. It can lessen your load if a breach was to take place, and you can prove that you did the necessary training. It can then mitigate your risk. Company always remains accountable. Remember that. Unfortunately, this is one of those acts that that doesn't take it away. So accountability remains with the business.
Okay, on step 5 on training. So the company is gonna keep a roster of who's been trained. A good place to start might be to read some of those definitions to them, right? Or anything regarding the POPI Act. Just trying to think what a company can use to train their individuals.
Well, that is one set of documents that you can share with them. You can circulate that within the business, and you can make them aware of it. But just circulating them doesn't mean that someone has been trained. So it's important then to make sure that they actually understand what has been conveyed. So one can set up a small test and see if they understand. You can get an external company to come and do the training for you. You can look at online methods of doing that as well. You've mentioned a few here in the package. So if you want on the job training as well, that can also be done. So there are a number of ways that one can do this.
So am I right in saying there's no prescribed module or CETA qualification or anything like that that has been prescribed by the Act? It's just asking you to train your individual. So if I show them some material, go through the Act with them and make them understand and sign that they've been trained and they do understand, that will be sufficient?
Yes, that should be. It doesn't have any guideline, as you say, and so it's important to note one needs to. The burden of proof is always on the responsible party. So it's always on the company. So whatever you do, it doesn't tell you how to do it. This law is not prescriptive, but it's a principle-based law, and therefore the burden of proof is on the responsible party. The company is the responsible party, and the company needs to prove that they've done sufficient training. And that's why we're saying, try and keep a proper, complete record of your training, and try and be as thorough as you can.
Okay, and so there where it says go to the master file, if we can quickly jump to the master file where we can just keep the records of the training that's been done, the training roster. So I'm just going to go and record everybody that's been trained and whether I've got a document with a signature. Does that last column with signature mean that somewhere else, obviously, I've got the real roster where they've signed, right? I'm just going to say yes there.
Yes, correct. Yeah, you will have a risk. So your training method, you specify your date, you specify, and then your signature will be a yes/no field.
Okay. All right. Let's move on.
Okay, let's go back there. So data subject, let's go on. Step 7. Personal data of the data subject to be managed. Over here, you're trying to complete your master file with the relevant information of all the data subject types that you have. Let's just go to the Word document again. Okay, so as we go through there at the top, it says functionally describe the processing of the information below, and go to your master file. List the details. You're collecting names, ID numbers, and. There's a whole list on the right-hand side of the page. You have name, surname, ID number, address, date of birth, bank details, medical conditions, and the like. So it's important to jot down all the relevant sets of information. So in here, you will define those categories. Like we said at the top, let's say, for example, employee or a customer or a supplier, whatever it may be, the channel or the method for which communication normally takes place. Let's go there.
So Johan, let's run through a real example. Maybe if you can also zoom in a little bit. If I identify a customer, I'm going to say my customers are a data subject category. So I'm going to say customers. I've got 100 customers. It doesn't matter how many I've got. Am I right?
That's correct.
Okay, so I've got customers. The method I have got, collected is the word I'm looking for. Collected their information was via, let's say they reach me via my website. So let's choose that.
Yeah.
Do I have, okay, here's a good question. If I've got customers and I've gained them via my website, but I've also got a sales rep that goes and knocks on doors and signs them up, does that create a new category of customers?
Yes, because what you need to do, these guys coming through the website has volunteered their information to you, and to a degree, they submitted to it voluntarily. So that's clear and that's simple. If you have customers that you approach in person, there will potentially be a different set of proofs employed. So that's why it's important, and as you say, it's a good question to ask.
Okay, so let's stick with the first example, collection instructed by, on the third column there in column D, that means, let's just see the drop down.
Okay, so once again have how was it instructed? Because remember, you need, when you obtain information, you need to also understand who authorized it. So if it comes by an email, it will be by that same method. So you need the proof and the approval about the information that is needed. So if it's coming through an email, you will have that as your proof. Your channel is also the same, email or website, because you need to then be able to refer to that and say, this is how I am and this is where my reference point is.
Okay, the reason for the data collection.
Contractual employment for marketing purposes, for medical, for supply information.
Yeah.
So
the biggest category there will probably be contractual, when I sign my customers up because I've got a contract to render some service to them or sell them something, right?
Yes, that is 100% right. And it's important to define this as contractual, because it's a contract to which they're a party. It's not something that's a one-sided agreement. They are the party, and therefore you have the information needed to conclude this transaction.
Okay.
Where do you store it? Where do you keep it? Whether it be on your servers potentially, and there might be areas like physical storage, floors. Maybe the salesman who went out came back with a piece of paper that was signed to say, yes, I want this purchase order delivered on, or I have it on a notebook that I was able to work with, or on my mobile device, my phone, I had the signature obtained on there. So where is it stored? Okay, access control method. Is there an access control method? It might be a biometric scanner. It could be manual granting of entry. It could be sign-in roster. In this case, for example, if it's on the local server, it might be biometrics, but it could be password protected. Okay, so that could also be a way to
Okay, so that's a good example that you're doing now. You're trying to put something in a validation list. So if you want to add something in your validation list, you can go to the tab at the bottom with drop-down lists and go to access control method. Let's go in there. Access control method, that column D, you just type in there in column D, password protected. And then once you've added that as one of the options in your column, when you go back, it will take that, it'll just be in the drop-down list, hopefully. There we go. Okay.
Super.
So that's good. That's good that we ran into that so that we explain how the Excel spreadsheet works.
Okay, protection risk, is it a high or a medium or a low? If it's on the website, it's under your control, and you have password control, you have access to who might have, because you only define certain people to have access. So at this point, I would say in this case, it could be a low risk.
So Johan, let me just ask the so what question here. So I am the business owner, are going to identify whether I think the data for my customers are secure. So I think the risk is low because it's on a website and there's firewalls there, and I may be hosting with Google or Amazon cloud or whatever, so the risk is low. If it is high, what does that mean? That is obviously the risk assessment where I am stating that I think I've got a problem with my files that are lying in the foyer, not in a cupboard, and it's open for public view, and that is a high risk. So that at the end of this process, I can actually just filter by the high risk data subjects that I've got to do something about it. Is that correct? Is that the purpose
Absolutely
of the
right.
exercise?
Yes, yes, absolutely right. You want to identify the highest risk items so that you can deal with that in a proactive manner. The higher the risk, the bigger the chance that you will end up with a breach. And so the sooner you can deal with those high risk items, the better you can take care of your business. It's important to note that this um, puts your business at risk if you do not secure personal information within the business. So it's important, as you say, then you target the higher risk first and you move on to your medium risk and your low risk. It's not that you ignore that, but you have put processes in place already to deal with those. Now, the next step would be after you've identified all these and said, right, okay, I need to deal with these. The next step would be to say, okay, now we need to put a new process in place and let us manage this to a level where it becomes a medium risk. And then later on, let us manage it to a point where it becomes a low risk. That's the point of doing this, so that you can actually make sure that you keep the right information at the right places of the right people, and it actually adds value and not risk alone. And that's why we said it's not a one-time event where you sign everything and now you're compliant. You have to continually go back, and I like what you said. You go back at least maybe once a month and review where you are and what needs to be done so that you can improve your system even more. Okay, in terms of access, you will want to know who has access. So potentially someone at IT has access, maybe not in this case. It might be secured to a level where only your profile has access. They can allow you to give access to anyone else, but it's important then to say sales team, salesman 1.
Johan, a good question here will be typically, so that's not a drop-down list. So if I've got the accounts department that's got access to customers, the salesman, the receptionist, I'm just going to list it there.
Yes.
Salesman, comma, accounts, comma,
Yes.
and you go online
yes.
like that. Okay, great.
Yes.
We can move on.
Okay, how long will data be kept? I think it's important to ensure that information isn't kept for too long, and that is one of the 8 conditions of the Act, is to do it as minimally as possibly. And so until the contract expires is usually a good one in terms of customers. In other instances, and there will be different sets and rules pertaining to different fields. So you might have some information that needs to be kept for SARS, which might be 7 years. You might have other information that you compile with another government institution, and they require you to keep it indefinitely. You need to have, for example, registration of properties. It needs to be kept indefinitely. So the proof of that needs to be kept there, and together with that is the security that goes with ensuring that nobody has undue access to it. So make sure that when you also look at the terms of how long, that you also define the terms of safekeeping.
So Johan, as a marketer, this interests me because until the contract is over, That's great. And as you said, always to keep as little data as possible is the name of the game, because that makes your risk of losing that data or having been breached makes it less. Because as time goes on and you just keep gathering data, your risk becomes bigger and bigger.
Yes.
Now, my question is, until the contract expires is probably a nice generic term, because once your contract is over, let's say you're a lawyer, you did a once-off job for somebody, you have to technically then delete that data. But if I wanted to sell something to that person in future again, or send him something, a new service or a new law that requires, him maybe to use my services, because that's in the best interest of my business, I want to make sales. This is where the tricky part is that you need consent from that data subject. Let's say that's your customer, that you can communicate future products to him, even though your contract is over. So it's good. I think it's good practice to have in your sign-up contract a clause that says, this is how long I am allowed to contact you in the future. And then if the customer doesn't like that, then they'll obviously not sign that clause. Is that a good explanation of it?
Absolutely, and column K helps with that as well, because it then says, okay, consent to keep personal information for longer than what was originally defined, and so then you can also say yes or no, and make sure that you have a consent form if they do say that you can continue doing that. It's also important to note that access to information needs to be given to anyone of whom you have information, so that they can contact you and ask you to delete the information from your system, or to correct it if it's incorrect, and therefore it needs to be open as well for scrutiny and management. So twofold, as you said. The one is so I can use it again for marketing in the future if the contract does come to an end. But if you said, I'm keeping it only as long as the contract is going, and the contract comes to an end, then you need to destroy that information. You may not keep it longer unless you have the consent. You may keep it longer.
Got you.
Okay. All right. So if there's a mutual need, this is also stated, to keep it, then you say, right, okay, there is, and therefore you will keep it. Now over here in column M, for example, now you have your different drop downs of all the different types of information. So you might have a name. In the company's case, let's say it's a sales team, you only have the name, the surname of the individual that you're dealing with. You don't have the ID number. You will have an address, which you can add if you want. You can add bank details, yes or no, medical conditions, yes or no, medical aid. Most of these things in terms of customers you won't have. Employer, employee. So in this case, it's a supplier to you. So you would say, yes, I have that. So I have supplier information. And the email address, yes, I have that. I have the post box details, banking details, because it might be necessary for you to have their details as well in terms of credits. So this helps you to just complete all the various sets of information pertaining to a particular, in this case, a customer as a specific data subject type.
So that is a long list of personal types of information, but it's not exhaustive, right? So if you've got something of a personal nature which is not in this list, you can just add a column and go and say, yes, I do have this as well.
Absolutely, yes. Yes, yes, because the list could be as long as 50 pages of the types of different information that we might have. And once we start, it might at first appear that this list is long-winded and drawn out, but then you start thinking and you find means and ways that you didn't even imagine beforehand. Let's go and say, right, okay, you planning to go on a business trip. You're sharing information with your flight agency. You're sharing it with, let's say, for example, a car rental agency. So the list can continue. So it's not exhaustive.
And then also, it's probably best practice to list all of it at first, and then have a look at it and say, do I really need that? Is there, like in column L, do I have a mutual need between the parties to keep this data? I mean, I would imagine you don't need somebody's eye color to sell him candy floss or whatever. So if I don't need that information, rather not collect it and actually even delete it, because the more data you keep, again, the more you are exposed. Is that correct?
Absolutely. Yes, absolutely. The more you have, the bigger your risk, and the more you have to manage.
Great. I think we can move on. So the data subjects tab on the sheet is quite a large sheet. So a lot of the instructions, I think, actually refer to it. So when we get to places where it asks us to go back to the sheet, we can obviously skip it and not go to the Excel spreadsheet.
Absolutely. Yeah. Okay, so let's go to 6, which is your strategic risk and impact mitigation. Okay, and then we say, right, okay, look at those associated with the company and who influences personal information. It's important to note that an operator must be bound by a contract to protect your data subjects' personal information. So you might have someone who is doing work on your behalf, and it's important to make sure that you are keeping this under wraps and making sure that you have a good contract that defines what may be used by that operator, who they may share it with, and for what purpose, as well as that they can come back to you immediately if they expect or suspect, rather, that the breach might have taken place. So this is important. This is under the master file data processes, and over here under the data processes. Under operators, for example, you will have here your operator, the name, the relationship. For example, it could be a third-party payroll processing, and the terms of condition is appropriate to allow sufficient protection at the operator. Make sure that you understand your operator. Make sure that you understand that they are a reputable company and you have access to their system. So it's not real time necessarily, but you are allowed to go and do an audit on their site if you want to share information with them, because it's crucial. They can put your business in disrepute as well. Okay, and then there are, let's go back to the page.
So Johanna, question here is that
yes.
You obviously need to diligently look at all of your operators that keep some of your data on your behalf, like your payroll company or some of those guys.
Yes.
And when you have scrutinized a contract, from there you will be able to put that information on a sheet. So it's all about a risk assessment. It's like somebody else is handling my data on my behalf and I pay them for a service. Do I feel that they've got a good contract in place? And then also, I think a lot of our customers do also operate like operators. So that's why you are getting the requests from the customer saying that, but you keep my data, tell me what you're doing with it and then your contract needs to be in place. So the time is now to get those contractual clauses and things in place. Is that
absolutely
correct?
Yes, no, for sure. No, for sure. I think you raise a valid point. Definitely.
Okay.
Okay, so this is a statement to say that I'm busy looking at this. This is what I'm doing. This is why it's important, buying this package to make sure the company acknowledges the information of data subject needs to be protected, be allowed to engage, risk assessment, how to protect personal information, and we have a high, medium, or low risk described in the master file for data subjects as well. So once again, this refers back there, and then it's signed underneath by the information officer and acknowledging that the impact assessment or impact study was done, so that it's clear that everybody can understand the seriousness of this. So the principal of the business also signs if it's not the information officer, if a separate information officer is being assigned.
Okay.
Okay.
I think that's quite clear.
Right. Let's go on. Next, we go to data indexing. So yeah, I think we have already touched on some of it. You go through your related companies and roles, internal accountants, your external accountants, your service providers, compile a list of them, third-party institutions involved, also South African Revenue Services, if you're dealing with Department of Mineral Energy, security, PE commissions, companies helping you in dealing with these DBI, supplier database, long-term insurance, all of these types of things to help you to understand where are your risks. So I'm trying to understand why my risks are here, and these could be one of the areas or several of the areas where they might be. So over here you have loads of history and thoughtful input to help you think through and work through areas that might lead to risk. Right. So they will help you inform this as well. Okay. Remember that the information on this is to help you with your employees and your employee contracts. You want to make sure that your employees inside the company are also taken care of personal information. So you will also work in this environment with a little addendum that you can have your employees sign by also having your witnesses sign. Use your own letterhead and company details and help them go through this, understand what it's about, why you have this different sets of information, and ensure that every employee signs it, and you file this not in your POPI manual, but you file this on the personnel file, which is a confidential document. Okay, let's move on.
So that's quite clear. We earlier mentioned the employees, you need to inform them and the method in which you inform them. So that is the annexure that every employee has to sign, and you just file that with a current contract, right?
Absolutely, yes. It will go with your current contract. It helps you to just keep all your eggs in one basket, and so that Not that you mash them all, but so that you can keep control of it in the right.
So this is not a part of your POPI manual because there's personal information here. You're just going to put it with a contract, but on your spreadsheet, you're going to indicate that you do have these documents.
Absolutely, yes. And that's why we say use your own letterhead and company details, because you're going to include this in the personnel file, and you're going to make sure that they understand why you're using this and for what purpose and how long you're going to keep it. It's important that you do this because a number of times we as businesses and employees think one thing and the other party doesn't necessarily think the same thing. So this helps to put the two parties together and to get clarity.
Okay, let's move on.
Okay, so over here, for the POPI Act, the company is an organization that needs to be engaged in aspects of business. Follows personal information could be processed in some of the following categories. And over here, you're basically stating what you are doing. This will, as we say in green here, this will become your privacy policy. And underneath here, you can say all your different interactions that you have. You will have employees, you will have clients, you will have vendors, but this will be your own list. And so this is an example. So you can use it just as it is, or you can tailor it to make it your own to ensure that it's 100% accurate. You will say then, okay, I've got employees and I have the following information of employees. I have clients, I have the following information of clients. I have vendors, I have the following information of vendors. And your information officer signs that. So once again, just to make sure that the information you have from over here from your data subjects, you link it through, or you can link it if you can link it, that's fine. But I pull it through into this document so that it is clear to anyone who wants to contact you to understand what information you use, for what purpose you use it, and with whom you might share it. So over here, this is the summary of that, and your information officer will sign it.
Okay, I think this is straightforward. So this becomes your privacy policy. You can load this to your website or put it to, with your other company policy documents. And the list that we've got there are not exhaustive, but you can add to it or take away if it's not applicable.
Absolutely.
Okay.
Okay. Now, I think I skipped number 10. Let me just find number 10 quickly. Okay, I think we covered number 10 to a degree, processing of processes. Okay, so we've already dealt with the processes and operators in terms of the processes over here. And remember that you will have people internal to your company also dealing with the processing information. So over here you can state them as well. But just make sure that you also refer to that safeguard. Make sure that you are putting your personnel file. And that will say, yes, I have signed the document. And so I have someone who has worked with it. For example, let us say HR has worked with information. It's an internal process for human resources. Could be and the head of the department has signed that document. So you've already managed this. And then the operators we've dealt with at an earlier stage. So, okay, so next is the data protection policy. All the steps will then become your data protection policy, and that you also need to add your policy to load your document and website. So it's addressed security on personal information. You're thinking of, in this case, your bigger cybersecurity situation with endpoints, with data in transit, with data stored in the cloud. There are all sorts of other nasties that come around. So remember to come and look at this, because it helps you to think of all those malicious types of problems that we encounter in the world out there. Virgin Active recently had a nasty when they had some ransomware take over their whole system. So these things are out there. Watch out, be careful, make sure you have the relevant protection in place. Make sure your company officials are informed, and that unauthorized persons have no access to personal information, and those who hold the process information must consent to be under the surveillance while working with your information. So you might sit with the situation where you don't have everyone in the business working on business equipment. Let us say, for example, you're asking someone to use their own private phone. Important to put that into the contract, that while they're using it for business purposes, you may monitor the use and the sharing of information on that device. If not, they should cease, and then you should offer them a device from your point, because you cannot have exposure because of an unprotected device being on your network. Okay, so that's the 24 states that to a degree as well. It's to be like a mobile device to be treated like a firearm. You cannot let them lie around. There are so much processing power in the mobile devices and tablets and the like that you can unleash a whole lot of damage to a business by leaving that lying around. Encryption is important. I know many small businesses are saying encryption is expensive, and there are ways and means to limit that. So watch out and look at all the things. We're not saying do all of these. We're saying look at this, consider it, and take it seriously, because this can be detrimental to your business.
Johan, can I ask a question? So if I look at this and I was a business owner and I've got one PC or two PCs and 3 phones, and I haven't really ever thought about these things. It's maybe a good idea to almost give this document to a company that does cybersecurity and give a quote to get all of these things done. Maybe there's a product that they can install on your laptop and look at all of these steps so that you can be true to the privacy data, the data protection policy that you actually want to prescribe to. Or if I've got and help me if I'm wrong, or if I'm a company that is already established with a service provider of some IT company that looks at these things, the simplest thing is to send this whole thing to them and say, guys, you let me know how protected I am because this is what I pay you for. Is that correct?
That's a very good suggestion. Yes, yes, indeed. That would be, like you say, someone might be paying already for an IT company to provide services. Let them then come and say, yes, we are complying with this. And if someone does not have anything like that, the smaller business, one PC in the office, but it's connected to the internet somehow, it's good advice to get someone in to come and advise you on this.
Okay, great. So this is best practice on a page almost.
Yeah.
Not best practice, but a good framework of what you need to protect and how you need to protect it. There's going to be somebody that either does your stuff already or you don't have anything. So you need to start to look at somebody. And for your own sake, Johan, you made the example of ransomware, which is extremely scary. I think a couple of days ago, a big company in America had to pay $11 million of Bitcoin over to somebody because criminals installed software on your computer that just freezes your whole system. You can't trade, you can't do anything, and your business is standing still. And unless you pay them money to let your system go again, you're going to go out of business. So it's very scary what the criminals are doing out there. So by all means, I think in terms of data protection, this is almost the heartbeat of the POPI Act, is to be able to protect people's information, and never mind personal information. The own livelihood of your business very much depends on this piece of work. I don't know if that sums it up in a good way.
Yeah, I think you do. I think you do, because that is, I think, exactly what led to the Act being published, is the proliferation in all these various means of gaining access to personal information and the misuse and abuse of that. So yes, I think that sums it up quite succinctly. Okay, then below is a set of steps to consider for your data breach incident plan. Important to note that in the case where information breaches does take place, you need to inform the information regulator. So you need to blow the whistle on yourself. You cannot just try and hide it under the carpet. So you need to notify the information regulator and every data subject whose data has been compromised. So take care of this. Make sure you read through this and have a plan ready for dealing with it if it happens. It's important that that you take it through the necessary steps here. I think it will help everyone within the company. It doesn't only have to be the higher ranking officials here, but even the lower in your echelon to know exactly what their roles are and how they are involved. So as Jacques, as you said at the beginning, if someone sends an email with all the company information for selling shoes to someone, that can damage the company's reputation no end. And so it's important to guide them, train them, and ensure that they understand what it's about, and then also within the company to react correctly as it happens.
So Johan, interesting story. So if you send a bulk emailer to all of your customers and you don't blind CC them, does that mean that I've actually breached myself by sending 2,000 customers all the email addresses where it's viewed by everybody that I'm breached?
Yes, you've done that because, yes, you've shared personal information. Personal information is also seen as an email address.
So that happened to me once. Interesting story. I worked for a beer manufacturer and I did that. And everybody replied saying, well, you've shared all of my information. Can we all have a case of beer? Now you can imagine how that turned out at the end of the day. So don't do that.
Yeah.
Just another question. So when you are breached, it doesn't mean instantly that you are going to get a fine, right? The information regulator knows that there are criminals out there that can also hack your system, and we know they're there. Otherwise, there wouldn't have been hackers out there if they still can do it. I think, and help me if I'm wrong, you have to whistleblow yourself and tell them that you've been breached. If you don't, then you can get a fine. Or if they investigate you and they see that you had no measures in place, in other words, you weren't POPI compliant, that's where the trouble is going to come for you. Is that accurate?
Okay, let me start by saying that the responsible party is the responsible party because they are always responsible, even if a hacker gains access. But if you can prove and you can show that you have put 17 hoops for this hacker to jump through by doing encryption and having separate third-party authentication before you can access any accounts or any of those type of things, extra steps that you've put in place, you are mitigating your risk. And you can, by notifying, you might face, but it shows that you are prepared and ready to cooperate. So it doesn't show an attitude of someone who wants to hide his or her mistakes. It's important also for all your clients to know upfront that a data breach have taken place or may have taken place. Because what would you do if, say, for example, you shared your information, your bank shared your information by accident with someone and they were able to access your account and withdraw the money from your account. Now, if they didn't notify you when they found out about a breach like that, you are not empowered to take the necessary steps to safeguard your account. The fact that they found it out and notified you is actually to your advantage. It doesn't say I'm not careful enough. What it does say is I actually care enough about my customers or suppliers or whatever it could be that I want to protect them, and I will even go to the point of reporting and facing whatever could come my way so that I can safeguard information of people, my stakeholders that I deal with. So reputational damage is probably the biggest one that one could face by trying to hide this under the carpet.
Okay, I think that covers it. Let's move on for time's sake. I think we're on the hour now, so if we could finish in about half an hour, I think that will be
okay.
That will be good. The advantage of listening to a recorded seminar, at least, is that you can pause it and go for a toilet break. So I think we're in a good space, but let's move on.
Okay, this is data subject remains the owner of his own personal information, and it's important that the data subject consent, that the initial consent allowing the company to hold the specific information. So this just reminds you to obtain the consent before using information from any of your data subjects. It reminds you to keep a record of that as well, because we're dealing here with 8 conditions. It is specific about the personal information. You need to understand that it needs to be ongoing. So if in a year's time it's no longer necessary, take it away. Confirmation to the data subject of his right to access the information, purpose for which it is to be held by the company. You cannot just hold personal information for the sake of holding it. And I think we've dealt with that. Who in the company would receive and hold that information, the length of time, and how and with what will it be destroyed. agreement identity of third parties to whom it may have been shared or seeded with. So it's important also to remember, if you do share it with somebody, that you are in a position to recall that, because you need to cover yourself if you shared it and something went wrong, and it needs to be revoked from that person. Okay. Over here we are protects information. This states consent form, so that you can send this out to some of your stakeholders and ensure that you have the relevant consent as required.
A practical question, Johan. So let's address this thing about consent again. So this is a form which you can take this information and put it in a form to get consent. 99% of the time, or 90% of the time, most of the data subjects that I will have consent for, because they're a customer that willingly used my service or accessed the form on my website to come on board, or I had a salesman that engaged somebody that signed up willingly for a service and I'm servicing them. So this is in the rare case where you have information right now in your system that you would like to keep for future, where you now need to ask that data subject, can I please still have your information, and give a good reason. So I'm trying to be practical here as a business owner. If I identify a bunch of data subjects where there's no reason for me to have that information still, but I still do want it, this is where this consent form comes in, where I send you something and say, Mr. Customer or Mr. Ex-customer or ex-accountant that used to do work for me or whatever, can I still have your data on record? Am I right in saying that?
Yes, you can do this in those terms where there have been a business relationship in the past, and it might not be an active business relationship at this point in time. It might have been a transfer attorney 5 years ago, or whatever the case may be, and you might have their information or they might have your information, and it's a way to just clear the way and ensure that everything is neat and tidy. Rather, if you are looking at a wall of information that you say, oh dear, I don't think I'm going to get through all of this, rather de-identify it by removing some of the information so that nobody else can identify it except yourself, so that even if it does get out, it will be worthless to anyone else. But to a degree, you will be able then to remember that if someone like that comes back, you can still take that up. If you
yes. So just another question, you're not in the business of marketing, so you might not have all the answers, but for companies that, and where a lot of data gets exchanged is in the area of marketing. And I think a lot of data gets abused in the area of marketing. We all get our spam calls daily, etc., etc. So for me now, as a business owner, to keep information and get consent for it, I think the law says I can only ask for it once, right? If the subject rejects you, then it's the end of it. And secondly is now, give me one or two examples in your mind that you think could help by getting that consent. I've always said in the past, perhaps if you can add some value to that communication. So if you send an email and say, please give us permission to keep your data, or perhaps to subscribe to a newsletter of some sort, so that if you subscribe, then at least you've opted in again to get communication from me, because I, as a business owner, might want to sell stuff to this data subject in future. Is that line of thinking correct, that you need to try and figure out a way to make it valuable for that data subject to opt in? Because as I said, and you must help me if I'm wrong, you can ask them once. It's not like you can send them 70 mails until they've accepted for you to keep their data. Is that correct?
What this is about a direct, unsolicited marketing. And so the point is, in that case, yes, you're right, you can approach them once, and you cannot even approach them. Let me go one step back. For direct electronic marketing, you may not approach anyone without their consent before you approach them. So for direct electronic marketing, you can only target a specific person if you have their prior consent. There's a Form 4 in the law that you need to obtain and have that data subject sign it and say, yes, you may target me directly. Now, between the information regulator and the Competition Commission and all the other legislation in the country at the moment, I think it's going to be a little bit of a tug of war there, because on the one side they've said that's fine, you may do that, and now the POPI regulation is saying something different. So that might still be something that ends up in court. But in terms of your own clients or customers, you may send them communication. And that's where the refuse once comes from. So you might then say, okay, here's my newsletter, and there must be a document, a tick box. If there's a tick box, then they can say, I don't want to receive this, or I do want to receive this again. So, and that's where the opt out is stated. So it's important then that when you do send out a communication like a newsletter that adds value, as you say, you are in a position where your customers, your existing customers, clients can say, yes, I want to receive more of these, or no, I don't. And then if they say no, that's that needs to be recorded, and so that you don't send that to them again.
Okay, got you. Let's move on. I think that's a very broad subject, the subject of marketing, which is not necessarily what this is about, but that gives me a good idea.
Okay. Okay, consents and consents.
We need to go to 15,
yeah.
Access management.
Okay, now this is a very thorough, and I think a very good generic form that helps with who has access to what within your business. It helps you to think through which individual needs access to which pieces of information. And I've seen these types of forms in various businesses that I worked before with confidential information and the like. So it makes sense. Everybody is clear on it. You have the applicant, you have the user, you have the line manager, you have the information officer, and everyone within the business dealing with this to take care of the necessary roles and responsibilities. So over here, you would put some extra information if you think it was necessary to say why they needed information, access to this specific role. So this is a good help in a tool. And I think that is that from this point of view. Then in terms of the fire manual.
So while you open while you're opening that up, I think there's quite a bit of confusion about the PIA manual. Previously, there were exceptions or what's the right word? Some people were exempted, some businesses based on their turnover, but that's not the case anymore. From the
Yeah,
1st of July, every business has to have a PIA manual. Is that correct?
yeah, that exemption has been planned for. The end of the exemption has been planned for the 31st of December, and then they decided to let it coincide with the 30th of June, so that the 1st of July everybody has to be up and running with PIA manuals. And a PIA manual is not a very uh, difficult document. It basically states some information about your business that you need to put down. It has what you need to load up. And in terms of where this affects POPI is in the fact that it then requires that when you have requests for access to information, you also need to confirm your access to information requests on an annual basis now in terms of the PIA and POPI together.
Johan, you're not on the PIA document at the moment.
Which one is this?
I'm seeing document 4, training the processes. So,
oh dear.
I was struggling to follow you there. So I thought I'll just interrupt you so you can go to document number 16.
Thank you. Thank you.
There we go. Okay.
Thank you.
Anyway, it doesn't change what you've said.
Okay, super. There we go. All right. So, as you say, it's the same information. You can see the act has actually been there for quite some time. It's not a new act. Nothing much has changed, except that, as I said, the marrying of the two, the POPI and the PIA, now means that there's a reporting responsibility, and we are in a position where this allows you to put all these sectors of segments or of information and put that together and put it through as part of your PIA manual. So as you see, it basically is informed by a lot of the information that you've already compiled and added into this document over here. So this data mapping really does help you to identify the flow and the means of information within your business.
Johan, tell me, so I'm just representing the small business that might have never heard of this, the Promotion of Access to Information Act, which means is that the government is trying to promote the fact that information should be freely available, which sounds like a contradictory to the POPI Act in my mind. But it means that a business keeps certain information, and I, as a consumer or a citizen of this country, has the right to inquire about some of that information. A good example in my mind is always like, if I want to know what your BEE scorecard level is, that would typically form part of this information or not?
That would be a separate one, but you could add it on here as well. It doesn't have to be. The information listed on here would normally be the minimum required, and it is, as you say, it looks like it's contradictory, but it's actually not. I mentioned it a little bit earlier. It is like two sides of the same coin. The one side says there needs to be public access to information. So it says I have information of clients and employees and suppliers and third parties, and I'm holding it in this area, and it pertains to all the following categories. It doesn't say specifically and particularly what that information is. So you're still protecting it, even though you're sharing some of it. So from a company point of view, you're sharing some of your company information, your physical address, your whereabouts within the company. And so this just goes with the prior information that you add.
Okay, so if it says that I hold suppliers' information, it doesn't mean that somebody can inquire from me and say, "Give me all of your suppliers," right? I mean
No, they
that's
cannot.
not.
No, they cannot.
Yeah. Okay, that makes sense.
The same with the BEE. If you don't want to share it, you don't have to share it, but it doesn't make business sense not to share it. So
Sure.
yeah.
Okay, that makes sense. All right, so we are almost on the last document. I think the last one left is the gap analysis, which is the Excel spreadsheet that we also offer as a free tool on our website. I tell people normally that doesn't necessarily give you the tools to get all the way to compliance, but it's a good indication of what needs to be done, although you still need templates and like we've provide and policies and procedures and things. So I always advise when you get to the end of your process to go through and honestly assess yourself according to these questions. And if you score 100% on this, then your company will be POPI compliant. I don't know if we can say anything extra about that. I don't think we'll have the time to go through every one, but that's what we've done just now. Yes, that brings us to the end of the seminar. Johan, thank you very much for your time on this. I'm sure we'll release some extra seminars and modules that will help perhaps with subjects and categories within the POPI Act, like the marketing dilemma that some of us have now, and so on. So we want to take this opportunity to thank everybody that's purchased our DIY pack. We really believe that it's the most affordable and best value for money package that you can buy out there in the market at the moment. And if you haven't bought it yet, please go to easypopi.co.za and go and download it there for once off 1,999. And to all our customers, we'll see you soon and give you more information as this journey unfolds, this new journey that we all have to embrace. So thank you, everybody. Until next time.